On March 20th, 2025, Byron Laws appeared before Judge David Fletcher in Harris County Criminal Court in Houston, Texas. Laws faced charges for driving while intoxicated with a BAC above 0.15, stemming from an incident on October 5th, 2021, and the case remained pending. On this date, Laws was represented by newly appointed defense attorney Anna Eddy. After reviewing Laws' file, Eddy asked Judge Fletcher to re-examine whether there was probable cause for the arrest. The Supreme Court established in Gerstein v. Pugh, 1975, that under the Fourth Amendment, a defendant arrested without a warrant and charged by a formal criminal information must receive a timely preliminary hearing to determine if probable cause existed. The court clarified that a prosecutor's opinion alone is insufficient. A neutral magistrate must decide probable cause. Texas law codifies this in Article 14.06 of the Code of Criminal Procedure, requiring that anyone arrested without a warrant must appear before a magistrate without unnecessary delay, and no later than 48 hours after arrest. In Law's case, such a determination should have occurred in 2021, but Eddy requested that Judge Fletcher reconsider probable cause.
I'm approaching on Laws.
Okay.
It's the last name. He's on bond.
Okay.
He has a BVR, but can we hear PC on this one?
Sure.
All right, there's this.
You don't think there's PC?
Laws.
No.
Law. Yes.
You don't think there's PC?
I don't, looking at the DIMS, but reasonable minds can disagree, Judge.
Have we done PC on this before?
I don't know. This is an older case and I just got appointed on it last month. So.
Did you already approach on PC on this?
I have not.
Don't worry about
And
it.
I'll just be honest, Judge, I had assumed because of the age of the case that PC had been done. But,
Of course it has been.
right.
But there's a new set of eyes, you know? Okay, ready?
Yes, Your Honor. Sorry, just reading through it. 2021 case. On October 5th, 2021, the officers were dispatched to a DWI call. The officers were dispatched to a possible intoxicated driver call. The witness stated he observed the defendant to go in and out of lanes as well as making a turn on the highway, heavy traffic. The officers conducted a traffic stop. The officer observed the defendant to have glassy eyes, slurred speech, odor of an alcoholic beverage, and poor balance, and an order for quiet, please, hold beer inside the vehicle. The FMSTs were conducted. It was a 6 out of 6 on the HEN, a 7 out of 8 on the walking turn, and a 4 on like stand. The breath is a 0.15.
So according to the DIMS, which is the sworn statement that we use for PC, it just says the officers initiated a traffic stop on the defendant's vehicle at an address, and there's no reason given in the DIMS for the stop.
She read something different.
That was
Yes.
not in the DIMS.
That seems to be from the offense report.
Sure, I mean, what's...
But I thought for PC, we just used the DIMS because that was sworn to, and not getting into the.
Show me where it says that. I don't know of any rule that says that it's PC has to be done on just the DIMS.
Okay.
You know, I don't. If you can direct me to something,
Okay,
but I've
and that just may
never.
be my misunderstanding of a
Yeah,
policy.
I don't. And I've heard this before.
Okay.
Right, but I can't. I've never seen anything where someone has ever directed me to saying, "Hey, PC is only
Well, it's
has to be just on the DIMS." You
because
know.
the DIMS is sworn, and just like when Judge Powell was up here and he wanted to get into the facts, he couldn't.
I mean, if he's getting into the facts, then that's something different, right?
Well, and getting into
Sworn
the
document too.
offense report's on a sworn document.
I mean, I guess, Your Honor, my thing is it's a public record that they're using the DIMS taking the offense report. And also, I have never seen it where we have to rely solely on the DIMS for probable cause. It's probable cause. In fact, when we go to the grand jury, that's all offense report, that's all DIMS, it's everything that comes in, it's even evidence. And that's probable cause.
Yeah, I don't know. I don't think that. I mean, let's look because I don't know. You know.
Okay. I'll stand
And
down.
I'll
Go check with
sure.
Ms. Rogers.
Eddy argued that probable cause should be assessed based solely on the District Attorney Intake Management System, DIMS, and not on the post-arrest offense report. DIMS is an electronic system used by Harris County Police to submit criminal charges to the District Attorney's office. For warrantless arrests, The arresting officer contacts an assistant district attorney to confirm probable cause. Once approved, the officer completes the DIM submission, which includes officer details, defendant information, charges, a summary of facts, witness and complainant data, and property details. The DIMS manual specifies that the summary of facts must present a concise account of who, what, when, where, and how the alleged crime occurred, without referencing an arrest report. Once submitted, DIMS entries cannot be altered. In contrast, an offense report is a detailed post-arrest narrative, including witness statements, observations, test results, and additional evidence uncovered during the investigation. Eddie's position was that only the DIMS report should determine probable cause, and in Law's case, the DIMS lacked sufficient detail to justify his arrest.
So you're saying that the DIMS has no reason for the stop, right? Is that what
Yes.
you're saying?
The sworn statement, and speaking with Ms. Rogers, we're looking, but it's not,
And I'm looking to.
okay.
I am too.
There was a class action lawsuit, and as part of the settlement, the agreement was that Harris County would use the DIMS to support
Okay,
PC, but we're getting that all together.
me too.
Okay.
For the 26th.
Was there a result for that?
Yes.
Or is it in action now?
No,
No, this was some time ago. So this was before the DIMS summaries had an oath or affirmation at the bottom of it. So there was a class action lawsuit brought by the Civil Rights Court. And out of that lawsuit, it was just allegations of Fourth Amendment violations, because when a warrantless arrest occurs, the Fourth Amendment requires that a neutral magistrate make a finding of probable cause supported by oath or affirmation. So as a result of that lawsuit, Harris County settled and said, okay, we're not going to concede that we were violating the Fourth Amendment, but we will now include an oath or affirmation. So I think it is a Fourth Amendment issue.
I'm curious, so I'm curious, for PC purposes, can state use an offense report to supplement a DIMS? Or are we strictly going in the four corners of the DIMS and nothing else? I don't know.
well, the four corners of the DIMS is what's sworn to. The offense report is not sworn.
I find that really weird. How is it that they're creating an offense report and they don't swear to it? You know, because there's, in the offense report, you also have a search warrant. Like 9 times out of 10, you've got a blood search warrant, and that's sworn to.
That, Your Honor, if the officer makes something up into the offense report, he is committing a crime. So, I mean, I don't say that the offense report is not sworn to. It's a government record that this officer is putting his name on. If he makes something up or if he lies about something, that is a crime.
Right, but filing a false government document is a different crime than perjury.
I get it, but
Wouldn't that be filing a false,
Right, but perjury's
an official document?
a different crime. Because
No, but it would also under the purview of filing a false,
Well, Judge, if an officer came into court and was asking for you to sign a search warrant, and they just gave you their offense report, that would not be enough for their search warrant. And it's kind of the same idea. Because this is a warrantless arrest, there has to be someone swearing to the facts to support probable cause for that arrest. And similarly, with the search warrant, it has to be supported by oath or affirmation. This wasn't a warranted arrest, it was a warrantless arrest. And so it must be supported by probable cause. That includes an affidavit.
was there blood in this case? Okay. Okay, give me 5 minutes.
Okay.
and Your Honor, we're pretty case level.
Huh? Okay,
If it's okay with you, we'll take
can
a
you
look.
show them?
Yeah, that's fine. Yeah, no.
Eddie and her colleague reference a class action lawsuit on probable cause in Harris County, Lease versus Harris County, filed on December 28, 2016 by attorneys from the Civil Rights Corps and the Texas Fair Defense Project. The complaint claimed that Harris County violated the Fourth Amendment by detaining arrestees without a magistrate-approved probable cause determination, as the DIMS reports at that time were not sworn statements. The case settled on November 1st, 2017. Harris County did not admit wrongdoing, but the district attorney agreed to require officers to swear to the accuracy of facts entered into DIMS. After the settlement, Each DIMS entry required officers to certify under penalty of perjury that the information was true to the best of their knowledge, ensuring sworn statements could be used for probable cause determinations.
Anna, you ready?
Yes, Judge.
Mr. Laws, come up. We have court orders for a reason, and when you don't follow court orders, bad things happen. Do you understand? Yes. You were ordered to get an interlock and you didn't get it, or a portable device, and you didn't get it. That's unacceptable. When you don't, there are serious, serious consequences. The only thing I'm asking you to do, don't endanger my streets. Don't kill someone on the road. Do you understand?
Yes, sir.
I'm going to find no probable cause in your case now. But if you come back with a new case and you don't follow court orders, it's really not going to go well for you. Do you understand?
Yes, sir.
All right, good luck.
Thank you, Judge.
We were going through the lawsuit and, 2017, the county came into an agreement where we're basically holding it to a higher standard, so to speak. I mean, theoretically, could I weasel out of it? Yes, but I don't want to. I want to stick with the agreement that the county came to with the district attorney's office,
I'm not saying do this, I'm just for curiosity.
The DIMS has to state an offense, right? It has to have all the elements of the offense to go forward. The reason, I would presume that offense reports don't is because they're continually just updated and they're amended and they supplement it. So it would be unreasonable to have an officer every single time they swear to over and over and over and over, because you might get like 15 supplements.
And here's my question then for the board, and I'm not saying we do this in this case, I'm just saying for cases going forward. To me then, does that then behoove, does that say we can't take it to grand jury?
You can. Of course you can.
So,
Yeah.
Just because I find no probable cause on something, if you want to go indict it, go do it.
right, okay.
Absolutely. There's nothing barring you from doing that, right? Because if a grand jury finds something different, then that's on them. As far as me, I'm going to just hold to the standard that we agreed with the county in the lawsuit.
I'm just, and this is for my own.
And you're not going to hurt my feelings if you go to a grand jury. I don't care.
I know you, Judge.
Oh, really?
So we wouldn't be held to that same
You need
standard.
to you need to do what you think is right.
Okay.
Like I'm going to do it, and like she's doing it. The problem is that whoever had the apps, they didn't dive into it and really look into it as Anna did. Not everybody is,
This is required to
I understand.
which is good.
Thank you.
Judge Fletcher ruled that the sworn facts in Laws DIMS report did not support probable cause, in line with the Lease versus Harris County settlement. Since Laws was charged by information, a charging document filed by the DA, Fletcher advised that the prosecutor could still seek a grand jury indictment. In Texas, a grand jury of 12 citizens decides whether evidence justifies formal charges. If at least 9 jurors find probable cause, they issue a true bill, leading to an indictment. Otherwise, they issue a no bill, and the case does not proceed. Although Fletcher's ruling invalidated the current charge due to an insufficient DIMS report, the DA retained the option to seek a grand jury indictment. Following the ruling, the state moved to dismiss Law's charge, reserving the right to refile later. The court granted the motion. As of this writing, Harris County has not refiled the charge. This case underscores the importance of accuracy, transparency, and adherence to constitutional procedures in criminal charging. Properly sworn probable cause statements and independent judicial review safeguard defendants' rights and uphold public trust in the justice system. Ensuring every case begins on a lawful, well-supported foundation protects both individual rights and the integrity of the courts.